And welcome back, everybody. So we have a busy day here on Law and Crime, a lot going on in the network. We're covering two different trials. But right now, before we talk about any of those cases, there is always so much happening in the news, and there's things that are trending. So here is a special report about what else is happening across the country right now.
Here are today's top crime stories trending on lawandcrime.com and across the country. 3 co-founders of popular dating app Tinder filed a lawsuit seeking billions of dollars in damages against Tinder's parent company for allegedly manipulating financial information to undercut Tinder's valuation. The co-founders, Sean Rad, Justin Mateen, and Jonathan Badin, filed the suit in New York Supreme Court accusing parent company IAC Interactive Corp. And its Match Group subsidiary of cooking the books to undervalue Tinder and covering up an incident of sexual harassment involving Match Group's chairman and CEO, Greg Blatt. IAC has denied all allegations in a statement to Law and Crime. The judge who allowed the release of 5 adults arrested in a New Mexico Muslim compound for allegedly training children to conduct armed attacks is coming under fire. District Judge Sarah Backus denied a motion by prosecutors to keep the defendants in custody with no bail, arguing the prosecution failed to meet its burden to show clear and convincing evidence that releasing the defendants would endanger society. 11 children were taken into custody after the compound was raided. The body of a boy was found 3 days later. The 5 adults are charged with multiple counts of child abuse, and all 5 defendants are still in custody. Authorities in Florida have released cell phone video of the moments the son of a sheriff attacked and slashed a local rapper. George Chronister, son of Hillsborough County Sheriff Chad Chronister, can be seen on video attacking the rapper in a Tampa Bay parking lot.
What are you gonna do? He's got his knife out. What the fuck are you gonna do? Nothing. Again.
Chronister faces charges of aggravated battery after his stand your ground defense was rejected. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Thanks, Anthony. You can go to lawandcrime.com to learn a little bit more of the top trending stories. But man, we got to talk about that New Mexico case. And I'm so happy because I have a very special guest to talk about this very special story. Juvenile judge and trial attorney Ashley Willcott. Ashley, great to have you back here on Law and Crime.
Thanks, Jesse. Thanks for having me.
I'm confused. I need you to help me out. How does a judge release them and say they are not a threat when this was going on? I'm not sure I understand that.
Right. So she did claim prosecution didn't prove by clear and convincing evidence that it was a threat, but I don't know how that leap was made either, because from what my understanding is, based on the reports, there's evidence that these children were neglected, were abused, one deceased, and so I think that's good cause to not allow them out on bond, because clearly they're a threat if they're doing this to children. So I'm not sure where the disconnect is.
What about, even you take it past that, if they were training them to commit attacks? How are they only charged, and I'm not as familiar with the story as I should be, but how are they've only been charged with child abuse and neglect? Have they been charged with some sort of terrorist-related charge or trying to incite violence? I mean, if they're trying to commit attacks or a conspiracy to commit an attack, how are they not a threat, and why weren't they charged with anything more unless they were?
Well, they weren't charged with that. So that's one of the interesting things, Jesse, in this case, is they weren't charged, as I understand it, with any terroristic acts or threats or training these. What's been reported is that they were training these kids to actually commit school shootings. And so I'm going to assume, although never assume, but I'm going to do it for today's purposes, that the state has not presented enough evidence, does not have enough evidence to press charges on those counts, and didn't present that evidence to the court. Because certainly I think, again, and might assume that if a judge hears evidence that they're actually being trained to commit school shootings, clearly there's a threat to society, and clearly they wouldn't be released on bond.
I mean, this is pretty horrifying. Do we know anything about how that boy, the young boy that was found dead, how this might have happened?
No, I think that right now, based on the reports, it sounds as if he was malnourished, was not fed, was not given hydration. So we don't know that for certain. The autopsy report's not out, but I think from all indications that's a possible likely cause of death.
You know, Ashley, I'm sure you see all different types of cases, but I always wonder, how does something like this happen without anybody noticing, especially to young children? In your experience, how do people cover these things up?
Well, a lot of times, frankly, it's a system fail. So I don't know if it is in this case or not. But, you know, there's so many different people that should report. Anybody who sees a child that appears as if they're not being fed or if there are problems or the way they're being treated, schools, nurses, doctors. It's impossible to do everything in vacuums with children, and so certainly I suspect someone out there knew or should have known and perhaps failed to report, or maybe they reported and the state didn't act appropriately. You know, those are system fails that occur. I see it way too often.
Yeah, unfortunately. Well, we'll update our viewers as soon as we know more about this horrible situation. But we are going to switch gears here on Law and Crime, and we're going to focus now on the Shayna Hubers case out of Kentucky, a young woman who's getting a retrial in the murder of the shooting of her boyfriend, Ryan Poston. Now, she is claiming that this was not murder, this was self-defense. She had got her original trial. She was convicted by a jury of her peers and sentenced to 40 years in prison, but she's getting a retrial because one of those jurors was a convicted felon and didn't disclose that fact on the jury questionnaire. Lucky for her, she's getting a retrial. Well, our very own Aaron Keller is down there at the courthouse reporting for us. So here's a special report from Aaron. Take a look. Thank you, Aaron. Great reporting. We're going to hear more from Aaron a little bit later on in the day. I want to bring back on Ashley Willcott to talk about this case. Now, Ashley, we haven't had a chance to talk about the Shayna Hubers case. It's capturing the nation's attention, as all of our viewers here on Law and Crime. So I'll just start off from the beginning. What's your reaction to this so far?
Well, so far I'm going to say this makes for a very exciting trial in terms of watching because of the two very, very different stories that the prosecution versus the defense have. So it's going to be interesting to see how it unfolds. The thing that I'm going to caution is it really true or good to believe that a person who, even if a victim of domestic violence, resorts to shooting someone in the face 6 times, not once, 6 times, and claims it's self-defense? I don't think so.
Well, let's play a little bit of the defense's opening statement in case anybody hasn't seen this yet. This is where they are explaining a little bit more about the relationship between Ryan and Shayna and how this built up over time and how Shayna had no choice but to defend herself. Take a look.
Well, welcome back to Law and Crime Network. So there's Jeffery Willis's ex-wife, Charlene Bishop, testifying on behalf of the prosecution. I have the pleasure and honor again to be with Judge Ashley Willcott. Judge, how are you?
Good to see you. Happy to be with you as always.
Yes, every time I put on the guest schedule, I see you there. I get very excited and elated because I know we're going to have some great conversations. So, I mean, what do we make of this guy? I mean, you know, there's his ex-wife testifying on behalf of the prosecution. I can only say, Judge, my experience has been, and I certainly can personalize this, the last thing that I would want in the world is having my wife or my ex-wife testifying against me in a murder case.
Absolutely. It's going to be interesting to hear what her testimony is for this reason, Bob. This is one that there was circumstantial evidence, honestly, that a van was seen in the area of the gas station where the victim disappeared 5 years ago. And so I do think this is potentially a circumstantial case. So it's going to be interesting to see how they link up the ex-wife's testimony with this particular crime.
You know, Judge, we've gone back and forth with a lot of things. I know our audience, which is great, watches the Law and Crime Network, gavel-to-gavel coverage, great experts like yourself. But you use the word circumstantial evidence. And when you say this word to people, and I was always concerned as a prosecutor, you say it to a jury on a wholly circumstantial case, they kind of revile and say, oh, my God, it's a bad case. Give us a quick legal description of what circumstantial evidence is. And I think in Georgia it would be the same as Jersey, where they tell you it could be even more powerful than direct evidence.
Absolutely. So circumstantial is everything that's going to build up and put all together, and you're going to say, okay, we think this person did it. There's no direct eyewitness, right? There's no body in the and he has the actual weapon used to kill the body. It's none of the direct evidence that directly correlates, connects this defendant to this crime. But the circumstantial together can paint a really vivid, effective picture to say, wait a minute, this guy did it.
Judge, on the other end of the break, I want to talk to you how we explain that in Jersey to the jurors. We'll do that when we come back. Well, here we go again with Judge Ashley Willcott. Caught you looking the other way, Judge. You got
I was looking down.
You're not supposed to look down as a judge, although I've had some judges fall asleep on me. So,
no, I'm very busy with my notes, Bob.
All right, listen, Judge, let's get back to this conversation because this is a replay of a trial, and it gives a great guest like you an opportunity to explain some things that maybe the average person wouldn't know, but at a trial, a judge would be explaining in the jury charge or in the jury instructions at the end of a case how they should evaluate evidence. And we were just talking about circumstantial evidence. You were giving us a description. It's where you were actually inferring a conclusion from two pieces of evidence that aren't necessarily directly related. And because jurors sometimes believe that there's something wrong with this, at least in New Jersey, I'm curious about out there in Georgia, the judge will say, let me give you an example. For example, if you go to sleep at night and before you go to bed, you look out your window and there's no snow, and then you go to sleep, and you wake up and the entire block is covered in 6-7 inches of snow, you can infer from those two facts, even though you didn't directly see it, that it must have snowed the night before when you were sleeping. As opposed to direct evidence is where you wake up and you look out the window and you actually see it's snowing. Do they use that kind of analogy out there in Georgia? Is that a universal one or just a Jersey thing?
That's definitely not universal from my perspective and what we see here. But again, we don't have snow but for maybe one day a year every 3 years. So, you know, but yes, they do use an example to your point, Bob, because you want the jury to understand exactly what it means when it's circumstantial and that it does, you have to infer from it. You don't have the direct eyewitness weapon body with the person standing over it. You don't have that type of evidence, but circumstantial can be very, very powerful. And I have seen convictions based on circumstantial evidence. So it does happen.
Right. Okay. Well, listen, we're just going to throw, I want to finish this evidence conversation and compare Jersey and Georgia law here, but we're going to go back to the clip and we'll talk to you, Judge, on the other side as we listen to the ex-wife testifying against her former husband in this fascinating murder case. Okay. Hey, Judge, so there we go. We're listening to the testimony of the ex-wife on the stand. This is a replay of a trial. It's a fascinating trial. We got some other trials up in the queue here at the Law and Crime Network. Gavel to gavel coverage gives us an opportunity to talk a little bit about evidence, Judge. This, I always would tell my staff, was the Bible, the evidence book, because if you can't get the evidence in the guardrails of this book, it's like a football game. If it's out of bounds, it's like it didn't exist. So knowing the evidence rules to me is even more critical, and I hate to say it, Judge, it may get you a little agitated, than even knowing the court rules. Thoughts?
Yeah, I completely agree with you, and that's what the judge is there to do, to manage the trial, to ensure that evidence that's legally allowed to come in does, and that which is not allowed to come in does not, hence the reason for objections. But also I want to raise in this, it's really interesting. For instance, she said, oh no, there were no guns, right, because we had grandkids and that wouldn't be tolerated. So it's going to be interesting to see how the defense argues that means the circumstantial evidence isn't there. So there's some interesting pieces coming out around the evidence. Right.
Of course, you know, you can know all the evidence rules you can, and yet you can have a witness on the stand that you've prepped. You never know what it is that a witness may pop out with, but hopefully if you're flexible as a lawyer, you'll be able to move around it. But listen, Judge, you're at the Law and Crime Network. We got this great coverage, folks. We got the great judge. Get into the chat room. Share it with your family and friends. We're going to a break. We'll be back on the other side with more analysis. Welcome back. I'm with Ashley Willcott. We're going over the Jeffery Willis case. His ex-wife is on the stand. We're going to go to another section of a clip. Before I do, Judge, you know I love the chatters in the Law and Crime Network chat room. And it's kind of ironic to me that a Ty B, that's in BEE 2006, is talking about wasps that get into her window. She doesn't know how to rectify them. I have a rectification for that. My new puppy, my new beagle, Holly, loves wasps. And it's always a great confrontation to see. But listen, we love our chatters, all kidding aside. They do a great service by us, and this is how we keep this Dan Abrams production going, by support of those folks, because there is no other network, and I appear on lots of TV shows, Judge, that does it like Law and Crime and like Dan Abrams and this great staff of producers. In fact, right in front of me right now, we got a rundown that we're going to be doing here on the show. I love what we got coming up here. We're going to go to Gerald McCarthy. He's a computer forensic expert, and we're going to listen to some testimony. Come back on the other end, and I want to talk to you a little bit more now about evidence as it relates to expert witnesses. We'll see you on the other side of the clip. There we have a computer forensic expert. I'm with Judge Ashley Willcott down there in Georgia, trial lawyer. Judge, real quick, because we've been talking about evidence, and I love getting into these discussions, especially seeing the different states and how they handle it, and especially for our viewers. We talked about those guardrails. Expert testimony is one of those guardrails. There is specific, special kind of testimony, whereas an individual is allowed to give expert opinion. Can you explain to the viewers specifically how a lawyer goes about qualifying a person as an expert witness?
Absolutely. So that's the foundation that they have to lay. So it includes things like their education, their training, their experience, what they've done to be qualified as an expert. And then it's not good enough to say, I want to qualify this person as an expert. It has to be in a specific specialty that they are qualified to testify about. So for instance, in this case, I think you said it was forensic computer. And so you have to make sure all the foundation is laid for that specific specialty, that they have more experience than anyone else, not anyone else, than the average person to testify regarding that specific matter.
Yeah, excellent description there. And the difference is that an expert witness, moreover, has the ability to do something that most fact witnesses can't, and that is to offer an opinion about something, as the judge indicated, maybe beyond the average ken, as they call it, or knowledge of the average juror, and that'll assist them. And the judge will typically charge at the end of the case that whether you believe an expert or not, we saw this starting with OJ, Judge. Do you believe the DNA evidence? Don't you believe the DNA of any kind of expert rests upon the credibility of the witness himself, the facts the witness relied upon, and the jury just has to make a decision as to whether they find that expert's conclusions valid based upon the data of that case. Is that right?
That's right. And the other benefit of an expert is once qualified as an expert, you can give them as an attorney a hypothetical scenario, and they can then give their opinion.
Absolutely. Listen, Fun Free from our chat room, just to take a real quick diversion, brings up a good thing about sunshine laws and why some courts allow it to be televised and some don't. I've been in scenarios where they weren't allowed and then in scenarios where they were. Judge, what do you think is some of the reasons a judge would not allow it in 15 or 20 seconds?
Well, if it's going to prejudice the case, clearly the judge has the ability then to say that they cannot come in and it cannot be televised. That's, to me, the most popping illustration.
Yeah, and in a murder case that I tried where it was very, very publicized nationally, they put one feed in the courtroom and all the other reporters stayed outside the courtroom and all ran off that feed. I don't see in my mind at all why it would be that a judge in today's day and age with the ability to do it with little obtrusiveness to the jury wouldn't allow this. And I think that Fun Free brings up a good point that we should be talking about more transparency in government. But
sure.
Folks, listen, we are doing gavel-to-gavel coverage. Jeffrey Willis, we're doing replay, but it gives me and a great guest like Judge Ashley Willcott the opportunity to get into evidence rules and things that we normally wouldn't be able to do. So we're going to go to a break, and on the other end, come back with the judge. Anthony Velez doing it, taking it to Law and Crime, taking it to those vignettes. I usually like to do the funnier stories, but since I have Judge Ashley Willcott, I think it'll give us a unique perspective, Judge. What do you make of this thing going on here with the judge made a decision? Well, I've seen some vitriol against judges, but this is taking it to a new level consistent with the social media stuff that's out there. What are your thoughts?
Well, I got to be honest. Here's my concern. The law, as you well know, a judge has to apply the law to the facts. And I don't know what the prosecution presented. What facts did the prosecution actually present in terms of why these individuals should not be released or a threat to the community? Certainly from everything that we hear, right? This was a horrific crime. Multiple children, one child died. Obviously, we do not believe they should get out of jail. But the thing that I question is what facts, again, were presented in court that the judge is then required to apply the law to and decide whether or not they should get out of jail.
I agree with that. Obviously, we don't know the facts a lot of times, but we get these reports, and I guess what I try to do when I'm doing media stuff is to go across a spectrum of opinions and articles from what they would quote unquote call conservative or liberal or up or down, whatever it is. But I don't know if these facts are being so much disputed. Of course they could be. But then again, Judge, you know as well as I do, I've been involved in cases where there's a clear history, say, for example, of domestic violence, and the judge gives an ROR on a bail after they were in on maybe $100,000. The guy goes out and he kills his wife. Judges obviously do make mistakes, but this seems like, at least as the facts as we know them right now, to be kind of unbelievable as a decision.
It is an unbelievable decision, but here's what I want to add, exactly what you just said. You wouldn't believe how many child abuse cases I see in which judges allow the person who has allegedly committed the child abuse out of jail. It happens every single day in this nation, and at this point in time, you've got all these allegations of child abuse, and a judge has, again, let them out of jail on these allegations. It's terrible.
And Judge, you bring up one last point on this story that I think is really important. I talk about it all the time. In fact, I did a podcast recently with Lise Wheel on this, is the term discretion. It's a real doozy, sticky kind of thing here in the law, because while I believe that we should give prosecutors and judges discretion, I'm a discretion guy. One of the reasons we wind up getting into mandatory sentences and mandatory bails and things of this nature is because of, in my mind, cases like this where the discretion wasn't wisely applied. And you see people, and I've seen people that are in jail for a heck of a lot less than this, who could be waiting 2-3 years for a trial. And that's where, when discretion is being applied, it can be a very wobbly and unbalanced result.
Absolutely, and I'm going to go out on a limb and say this. I see it nationwide. Often in child abuse cases, the discretion is applied in such a way that the alleged abuser gets out, so I don't get it.
Yeah, definitely. And I don't know if there's any way to abate that. I believe that we should move in mitigating and aggravating circumstances and have some parity, or that is, we treat most people down the center unless you see things one way or the other. How do you articulate it? Well, justice is in the eyes of the beholder, and sometimes it's difficult. I'll tell you, in the 6 years I was the head prosecutor in the 21 different counties, we never had any discussions about uniformity of plea bargains, uniformity of disposition of cases. Everybody was kind of an island onto itself, isolated, and everybody would be offended, actually, if you were to tell them how to handle a case, hence disparate results on the prosecution side, and I would suspect judicial side.
Absolutely, and you see that across every state, every county, every circuit, all the different places throughout the nation. Now, I also want to say this, though. It does seem like when you have multiple victims of child abuse, like in this case, that certainly there should be some type of guidelines to say, you don't get out. Multiple counts, multiple victims.
Right. Great analysis, Judge. Hey, listen, we're doing the Jeffery Willis case, and actually we're going to show you an interesting clip. Go back to McCarthy, because I think, Judge, when we get to the other side of this clip, again, I love doing the replays because it gives us an opportunity to really greatly get into our audience to explain how lawyers, the nuts and bolts of things, because they see it playing out in court, but we know there's a lot going on behind the scenes and legally as the show, if you will, is going on. So let's go back to that clip, because I think it's going to help us with something that we were discussing before, that is circumstantial evidence. Welcome back. Hey, Judge. So this computer forensic expert, forensic fancy term for a guy who does computer expert testimony in a court setting or a legal setting, is indicating that on a forensic analysis of the computer of the defendant, there's a victims folder called Jessica, and if I'm getting this right, it was created 3 years apparently afterwards. Obviously, this is the prosecutor putting this forensic expert on. I've put many computer forensic experts on. I find it to be a kind of very interesting, fascinating field in terms of what's not on computers, but this is pretty powerful evidence for the prosecution. Where do you think they're going with it?
Well, first of all, it's really powerful because it's under a folder that starts with VIX, which you can assume is, or infer is victims, and then this victim's name, and then it goes from there. Here's where I think they're going with this. This specific computer information leads to an inference that this man was involved with the murder of this victim, because this is an abnormal interest, not typical information that someone's going to have all this information about the person murdered under a file folder on a computer that says victim, and it was created specifically on the 3-year anniversary.
Judge, excellent. You just gave the definition of circumstantial evidence. From this, you can infer he may have been involved in this crime. You hit it right on the head, Judge. We're going to come back after the break with more. We're at the Jeffery Willis trial, talking to Judge Ashley Willcott about the fascinating aspects of expert testimony with Gerald McCarthy, a computer forensic expert who's about to tell some pretty gruesome stuff he finds on the defendant's computer. Let's get back to it. Well, I have Judge Ashley Willcott with us, and there's some circumstantial evidence that is better than others. Judge, you had indicated, and I know I've heard a judge say a million times at trial, sometimes circumstantial evidence can be even more powerful and more persuasive than direct evidence. And while we don't have any specific evidence of this gentleman doing anything specifically to this girl in any of these computer files, I can tell you, if I were a juror, I would give it the legal term, this is creepy as heck, okay? Right? I mean, this does not look good, and this computer forensic guy pulled out some tremendous stuff for the prosecution that is not going to bode well for the gentleman in front of the jury. Thoughts?
No, the same. And the inference here again is that this is a man who had the ability and the capacity and was actually, my word, not in the legal sense, but stalking or tracking or specifically targeting this young woman at the gas station that's been murdered.
Yeah, I mean, all sorts of special equipment, all this stuff about the various folders and going to the schools. And I mean, it's just so powerfully circumstantial that he's a sicko, which is the sicko factor when you're trying to prosecute something like this. But I think that he's going to have a hard time escaping any kind of credible explanation for it. Of course, you could argue it's just fantasies and it's just whatever, but they have a ton of other evidence that connects this, Judge. We got 15 seconds. Give me an idea of what you think the prosecutor will connect this to.
I think they're going to connect this to the fact that the young lady at the gas station was targeted and somebody was watching her and murdered her.
That's right. Goes right to premeditation. Judge Ashley Willcott, always giving us the great explanations. This is the Jeffery Willis retrial. Please go online, get us in the chat room, ask us some questions. We've already answered a few because you can't get a better guest than the judge. We'll be back. Okay, Judge, it's sidebar time. We're going to move off the Jeffery Willis case. Gosh knows he's no judge, at least not in a good way. We're going to go to Kentucky versus Shania Hubers. And we've been covering that. I think Aaron Keller claims that he's out there covering this trial, and I know he is. And actually, Judge, we were talking about this a little bit before. We have a court that's not allowing cameras in there. Fun Free had asked that question about Sunshine Law. This is a murder retrial. Is it murder? Is it self-defense? And here's the defendant. They can't help themselves, Judge Ashley Willcott. They got to keep talking, got to keep talking. Well, even when she's in Stars and Stripes in the jail, here she is. Let's look at it.
You've changed. So how have you changed? How are you different than October 2012?
I think I've grown up a lot, and I think I've been through a lot, and I think I was a young girl then, and I think I'm a woman now, and I think that
Do you think you would handle situations differently now then?
yeah, I think I would handle things differently now as a 27-year-old than I did as a 21-year-old.
Yeah, Judge, I mean, you got to love this, right? So we have 1 minute, okay? Like, I love these people. They get to, yeah, I do things different. I'm a little bit more mature now. Like, maybe I wouldn't have shot him in the face and shot him multiple times afterwards. And maybe it wasn't right to say I was just giving him that nose job he always wanted. What do you think about these people that give these interviews? So the lawyers have to be going crazy, right?
Absolutely. First of all, I'm sure, assuming it was against the advice of her lawyer. Second of all, you know, it's really atrocious to sit there and say, well, I was a few years younger, so I thought it was okay to shoot him in the face and kill him. But now I think maybe I know not to. Really?
Yeah, I know. I mean, and all this stuff, of course, can be admitted in court in one way or another. And that really especially becomes important, especially in a self-defense case, Judge, or in an accident case, if the defendant decides they want to take the stand, anything they say can and will be used against them.
Absolutely. So it's amazing to me that they do speak. And I promise you it's against the lawyer's advice if it's a good lawyer. You never want your client giving these interviews, as you well know.
Right, Judge. I've been talking about Aaron as the Where's Waldo of the Law and Crime Network, my friend, my pizza critic. I'm told, I asked, and I wish there were other things I'd asked for, although I love Aaron, that we're going to actually go to Aaron and at least listen to a report that he filed with the Law and Crime Network. And I can't wait to see his face because he's no longer in the tri-state area. Let's see, Aaron, what do you got to say? Now I know for sure, Judge Ashley Willcott, that Aaron Keller is, in fact, in Kentucky. But I made a very critical observation of his interview because I believe is a great trial lawyer. You see it all. Did you see it, Judge? Did you see the one thing about Aaron that was amazing?
What is that?
The trees were blowing, the leaves were blowing. Nary a thing could stay in one spot except for Aaron's hair. You didn't see that?
I did. Now that you pointed out, good observation. You're right.
Well, he is guilty of having the best hair beyond a reasonable doubt. Hey, Judge, on a serious note with this case, you know, I love this. First of all, I really like a prosecutor. I know it sounds crazy, but I used to instruct my assistant prosecutors, don't be afraid to walk up to the defendant in the opening statement and point your, oh, put that picture back. That was exactly the picture I want. Point your finger right at the defendant and let them know that you are holding him accountable or she accountable for what they did. Don't hold back. Don't be afraid. Let the jury see the drama of that. I like that. What are your thoughts?
I don't disagree with you, because here's the thing. This is the stage. This is where you are trying to convince a jury of your position, whether it's prosecution or defense. And there are very effective tools. You don't want to be overly dramatic. You don't want to be insensitive. You don't want to be rude. But you can use tools like pointing to the defendant to make a very good point to the jury. I absolutely like it as a trial judge because it puts visual along with what they're saying and the evidence they're presenting.
Right. Doesn't sound like it's just being read off a piece of paper. Hey, Judge, let's go to the defense opening, and on the other end, we'll come back and talk about it. All right, Judge. So there's the defense giving their opening statement. I cannot count. I mean, seriously, Judge, I cannot count on my hands how many cases I prosecuted where it was, oh, we were struggling for the gun or the knife. Oh, he picked up the gun. Oh, I picked it up and he took it out of my hands and it accidentally fired, because she does give varying accounts of that. And here's the attorney basically bringing that up and basically positioning her as the victim in the case. How did you think it went over based upon all those other facts the prosecutor brought out?
I personally did not think that it would be convincing to a jury for a couple of reasons. Number one, we'd already heard previously that she's claiming that there was an abusive relationship. Number two, right then in that opening, they say the gun was on the table between them. If you're in an abusive relationship, in my opinion, although too many women are victims of domestic violence, some men are as well, stay in abusive relationships, but you're not actually going to sit across from the person with a gun in between the two of you if it's an abusive relationship. You're not going to put yourself in that circumstance. And then third, to hear that she picked it up and shot him, and oh yes, it was 6 times, or it happened to be 6 times. To me, that's not compelling, convincing that it was true self-defense.
Absolutely, and that's what wins cases, common sense points like the ones you just brought out, Judge. We got a Lieutenant David Fornash that's on the stand. Let's listen to some of this interesting testimony and come back on the other and discuss it with the judge. Right, so there we go. A little question there from the prosecutor with regard to one of the lieutenants, police officers, detectives in the case. Judge, this whole case, we had a scenario where we have copious amounts of text messages, emails, him basically saying something to the effect that, like, she's restraining order crazy. And in fact, the very night that he was murdered, a night he was supposed to go with a Miss America, I believe, or not, a Miss somebody, a beauty contestant person, was supposed to be going out on a date and seemingly looking to move along. And numerous times she was coming to his house unannounced, seemingly unable to end this relationship. So, these detectives are just explaining what they observed, but that's the context the prosecutor will put this case into, no?
Absolutely, that's the context. And so you have two very different sides in this case, and what he had done to her and why it was self-defense, and then what she was doing to him or allegedly doing to him to make her seem like the crazy one who wouldn't go away, who deliberately, with premeditation, shot this man to murder him.
Right, and real quick, Judge, there has been some reporting I did the other day, or from another reporter, about the Me Too movement. I find it to be a little bit disgusting that they would attach the hashtag Me Too, legitimate movement about women who are victims of domestic abuse, and kind of attach it to this potential woman based on these facts. So, but I'm not a woman. What are your thoughts?
Well, I think it's a fine line. I think that if there's been abuse and domestic violence, certainly understand, respect, it's proper. But in this particular case, there are two opposite sides of the stories. I've not yet heard anything to show that she really is such a victim, but maybe in the rest of the trial we will.
Well, listen, of course, if she were a victim of domestic abuse, then hashtag Me Too can go to her. It doesn't necessarily mean that you have properly utilized self-defense. It's a fascinating case to watch because it's got a lot of nuances. I'm here with Judge Ashley Willcott on the Law and Crime Network. You don't get better than this. Stay with us. On the other end of the break, we're going to come back with some more fascinating cases, folks. Thank you. Well, welcome back. Listen, we've got Judge Ashley Willcott with us, and we are all over in terms of talking about law, talking about the specifics of evidence, talking about this self-defense, hashtag Me Too, and we're also talking about Jeffery Willis, kind of a creepy case in and of itself. We just had the computer forensic expert, Gerald McCarthy. We're going to hear some more fascinating testimony that gets into that circumstantial piece that this evidence, in our opinion, at least my opinion as a prosecutor, wasn't there innocently. It was there in preparation, plan, and remembrance of a dastardly crime. Let's get to it. Well, as he takes a sip of coffee, Judge Ashley Willcott is with us. So this is pretty fascinating testimony from, again, this expert witness. And we had discussed before, experts have a special ability to give their opinions based upon training and experience. They go before you, Judge, right? They would try to have you qualified, and the other side would have an opportunity to do voir dire to determine whether they have the requisite qualifications or not. And then they get up and testify. Pretty compelling testimony.
This is very compelling testimony. And first of all, what is sick, you know what, when they have testimony that he's got pornographic video of a woman inserting a tampon. I mean, that just says it all. Talk about bringing the emotions of the jury into this case to say this man has some real issues. The other thing that I pulled out of this was the missing kidnapped flyer for this young lady who's been a victim and has been murdered. You put all this together, it's really compelling circumstantial evidence that this man has taken these steps to deliberately, with premeditation, murder this woman.
You know, that's funny that you should bring that up, Judge, because I think I had discussed that a little bit before about the mementos that people may take when they're either committing a crime or afterwards memorializing it. This is not an uncommon thing. Someday we should have a psychiatrist come on, and maybe one has already, to explain why this is. And I had a murder case one time. It was very stubborn, very sticky, very difficult to figure out. Of course, the bad guy sometimes will talk to you because you're just going around canvassing the neighborhood and asking questions, and they don't want to seem suspicious. That's one of our abilities to get statements. And then we found a couple of things that weren't necessarily stolen from this old woman's home, but they were there, like a pot, and I'm trying to think of her Bible and some other thing. And when we were asking questions like, why would you have that there? Then he has to start explaining why her stuff would be in his place. And that changed from the story that he didn't know her. And then all of a sudden we start looking at the evidence. It's almost creepily like this case. We see video surveillance, a video camera just pointed at her home. It was not concrete proof to not having anything to do with it, but that's certainly, well, it may not be circumstantial evidence, proof beyond a reasonable doubt, developed the suspect that ultimately we developed all the evidence and convicted him of. But if it wasn't for those little mementos, we would have had nothing.
Yeah, it is very common. I don't know why they take mementos, but they do. And, you know, fortunately for the prosecution, criminals aren't smart. And so those little mementos can sometimes be the linchpin in the case to say, wait a minute, this is a suspect and this may be the person that did it.
Absolutely, and certainly don't leave your computer records behind. Law&Crime Network, Judge Ashley Willcott, Jeffery Willis case. We're doing multiple things here. We got Aaron out there, doing his thing, and now we know that he's actually inside the courtroom, and he is doing what he can on the Shania Huber's case. Listen, all you folks out there, join the Law&Crime Network, get into that chat room, share this with your family and friends. It allows people like me and Judge Ashley Willcott to be able to give you this kind of program, 24 coverage. We got gavel to gavel coverage. We got all the coverage, murder, mayhem, law, and crime. You got it all here in one package at the Law&Crime Network. We'll be right back. Well, here we are, Law&Crime Network. I've had the honor and privilege once again to continue to be with Judge Ashley Willcott out there in Georgia. We've had some funny, interesting Georgia cases that we've talked about. I can't get the one out of my head with the guy jumping on the car and the lady still driving for like 15 miles with, you know, it's just no big deal. I'm just driving my car with a half-naked guy on it, Judge.
Notice that she sped up,
Well, that has all come from the top crime stories. And you know what, Judge? We have top crimes lunch stories coming up right now. We'll talk to you on the other end. Now, Judge, you know I love to talk about those top crime stories, but we are in the Jeffery Willis case, and it is a serious one. And I think we've done, I love the idea that we get to block this one thing into another. One building piece from a prosecutor to the next building piece. Positioning of witnesses is very important because the jury doesn't know the story. And so what happened? We had the forensic expert get up there, but that only makes sense in the context of how does it fit into the rest of the case. So the producers on this show, as is typical, and the group that's behind the scenes that makes this whole thing happen here at the Law&Crime Network, teed up for us Lieutenant Kasher, who is the lead detective, who then interrogates the defendant based upon what was found on the computer. And you need skills to do this the right way. One, to get them to speak to you. Two, not to invoke their right to an attorney. Three, not to get them to lie or play that game. And this is going to be interesting to watch. We'll be back on the other end. I am unfortunately going to have to tell you that our great guest, Judge Ashley Willcott, who is still with us right now, is going to have to depart. She had to leave earlier, but I wanted her to literally say goodbye and give us one parting statement based on what you know about this case, Judge, in 20 seconds or less before you go. And let me say, before you do it, looking forward to seeing you next time.
Thank you so much for having me. I always love doing this. I love this coverage of the trials and everything that you all there do and work so hard to make this work. I think he's absolutely a creep. I think the circumstantial evidence is going to add up, and we're going to see a conviction in this case. And always a pleasure to see you, Bob, and be on with you.
Well said. We'll see you soon, Judge. And guys, we're going to go back now to the cross-examination of this most important witness that confronted the defendant with regard to what was on his computer.